You're listening to the Hidden Killers podcast with Tony Brueski,
featuring former federal prosecutor and president of West Coast Trial Lawyers, Neama Rahmani.
DNA evidence is something that's been a pivotal part thus far in the case against Bryan Kohberger. And, well, some of that DNA evidence going over to the defense. Recently, Idaho prosecutors have submitted the disputed DNA evidence to the court in the case of Bryan Kohberger, who's accused, of course, of murdering those 4 University of Idaho students back in 2022. This is the IGG evidence, the Investigative Genetic Genealogy. The police used IG evidence to generate leads, but they say they did not use it to obtain any sort of warrants. The DNA sample on the knife sheath found at the crime scene was allegedly matched to Kohberger through a cheek swab. Here to join me and help kind of break down what this all means, Neama Rahmani, former federal prosecutor. Neama, what does this all mean? This is evidence that we've heard is not going to be used actually in the trial itself, but of course in discovery. Fair, I guess, to give it over to the defense of Kohberger. Why is this such a weird sticking point? Why is there a lot of attention on this specific piece of evidence right now?
Well, Tony, a lot of people have a problem with IgG because it can connect mine or your DNA that really isn't in the system because we have never committed a crime, but maybe one of our family members has. And that familial DNA gives law enforcement a huge advantage because they may have a DNA sample like they had in this case, and it might not be a match to anyone. But if they get to that next level, the family members, then all of a sudden they can say, well, maybe Tony or Neema's uncle had a problem with the law a few years back, and they can get closer to the person that they're after.
So what is so wrong with that if, in fact, it does actually lead you to a criminal or someone who has done something wrong that they are trying to track down?
Well, a lot of privacy advocates and civil libertarians think that it's unfair for law enforcement to be able to track someone down based on their DNA when they've done nothing wrong and they haven't had to give a sample. Now, of course, a judge can always order a DNA sample, and that's what we saw in the Kohberger case. But one, I think law enforcement doesn't want the public necessarily to know about this because it's such a powerful investigative tool. I think it helped catch the Golden State Killer, for instance, and Gone Girl Sherry Papini are 2 recent cases here in California that come to mind. But when they're really at a dead end, this type of analysis can lead to really sort of fruitful conclusions. And it's really so powerful. And obviously, each state is different. At least here in my home state of California, there's a special board that has to approve these types of requests. Law enforcement doesn't have access to everyone's familial DNA. The California Attorney General's office has to go to a very specific board that authorizes it in particular unique circumstances.
The fact that this is something new that's being used as a tool, is that why there's so much attention on it right now and so much, I guess, caution on it with some groups, considering it is a very valuable tool? It is something that can lead to arrests. It can lead to people who have done wrong, as long as it's not going down a route of we're incriminating people who are that are wrongly accused, because obviously the DNA is very specific. So if it is in fact a family member, but it's not you, where does the issue come in? Because we are using someone else's DNA as part of the path to get from point A to point B, that point A was someone else who didn't do anything wrong, but that in fact led us to B.
Yeah, I mean, that's part of it. So obviously, we would talk about the privacy concerns in the public and members of the legislature that may not like this, but it's another Fourth Amendment concern, right? Where, someone was compelled to provide DNA for some reason. And because of that individual, they may have waived their Fourth Amendment rights, or you might not have Fourth Amendment rights, right? So if you've been convicted, for instance, and you're on probation, right, you might not have a Fourth Amendment right to prevent a police officer from patting you down or even searching you because you're a convicted felon. But someone who hasn't gone through those procedural safeguards, someone that hasn't been arrested or convicted, may not necessarily have waived those rights. So it's a question of privacy. It's a question of constitutional rights and the Fourth Amendment. And really the final issue, which is the one we're really dealing with in this case, is discovery. So, setting all this aside, the state of Idaho is saying, well, listen, even though we did this, we admit to doing it, we didn't use any of this evidence in support of our search warrant and our arrest warrant to get probable cause, right? Our probable cause is based on, XYZ. And us following Kohberger to his house in Pennsylvania and getting his father's DNA and doing that type of match, right? So the question is, especially a case like this, likely death penalty case, there's going to be those mandatory state appeals. Regardless of what's been done, I really like the prosecution to produce evidence and discovery. I don't like it when they hold things back because you're creating a potential unnecessary appellate issue, even though I get it. Law enforcement, they don't want to tip their hands and let, especially pretty sophisticated folks like Bryan Kohberger, who are, PhD students, know what investigative tools they have in their disposal.
So could this in any way affect the DNA that was obtained through the other means, going to the home, getting the trash and tracing the DNA from his father back to Bryan Kohberger? Could this affect that at all, considering we're talking two different types of DNA and two different ways of gathering it? Or is this exactly what you just said? It's just, let's throw it out there, you can have it, and then it negates any sort of appellate issues down the road?
I think the state should discover it because it's a scientific test related to the defendant. So that's a separate basis. But I don't think it's going to affect the case. And this is why. When you throw something out, that trash, you don't have any Fourth Amendment protection anymore, right? Mm-hmm. It's been discarded. It's in the public domain. You're not maintaining the privacy of that piece of trash inside your home. So I think the state, they did a good job making sure to get DNA outside. Look, I think the familial IG DNA is fine. And I think it shouldn't be subject to suppression. But what they did was a really good job and just say, hey, let's just make sure, let's go try to get some of Kohberger's DNA. And he was very careful not to provide any. But they got the next best thing, which was his father's, and they were able to rule out 99.9% of the public. And by getting the trash, that avoids any Fourth Amendment issue.
Want to listen ad-free? Want advanced access to all of our interviews before anyone else?
Become a True Crime Today Premium Plus subscriber on Apple Podcasts.
You get every episode commercial-free.
So you can binge on true crime
until you can binge no more.
Search True Crime Today Premium Plus on Apple Podcasts now, or go to our podcast page and sign up now.
More of the Hidden Killers podcast next.